Well, first of all, Judge Mrazek has come back with his ruling for Kouri Richins about whether or not she can delay her sentencing. And the answer was no, no, no. He didn't feel like there was
Wow.
any justification for it, really. And they didn't really give very much other than they wanted more time and they wanted an extra day. But they, in typical her defense fashion, because we saw this all the way through the trial, they made a lot of requests, but they didn't give a lot of reasons backing up those requests.
Mm-hmm.
And the judge just did not feel like it was justification enough. And he said no. So we're going forward on May 13th
Interesting.
with her sentencing.
Yeah.
So they do
Yeah.
only get 1 day.
Mm-hmm.
The other reason was because it's unfair to do to the victims' families. The victims and, all of those families that
Yeah.
were planning to send people to speak that day, and they'd already agreed to the date. And
Mm-hmm.
the Richins family has seen a lot of delay already in this.
Yeah.
So she has been convicted of the first-degree murder of Eric Richins.
Mm-hmm.
So Kouri faces 25 years to life or life without parole, depending on what Judge Mrazek chooses.
I really like this
There
picture of her
are,
because she looks so much less smug.
yeah, I like this. This is her scared picture in my
Mm-hmm.
notes. Because yeah, for the first time, she looks like maybe this is for real, and she's got to take it serious.
Mm-hmm.
There are some potential aggravators in the case, which are more likely to, if the judge finds those to be legitimate, more likely to give her life without parole. The financial motive, the prior attempted poisoning are a couple of the aggravators.
Mm-hmm.
Um, they could reference her behavior after the death, the book, the media appearances, all those things.
Yeah.
Um, I do think that life without parole is very likely what he will give her, but I guess we'll see. But we don't have to wait because it's coming. It's coming
Excellent.
right up
I'm here for it.
on May 13th. So we'll be streaming that over on the Trials channel. Let's just talk about Tyler Robinson for a minute. Not a lot of update on Tyler Robinson. Mostly what we are doing is waiting for Judge Graff, which is what we are seem to be always doing in this case.
Mm-hmm.
But his preliminary hearing is coming up. And Judge Graff has not ruled on whether or not he will delay the preliminary hearing. Now, at the hearing 10-ish days ago that we streamed over on the Trials channel, the entire defense team stood up one at a time and told Judge Graff that they could not be effective counsel for Tyler Robinson and do his preliminary hearing beginning on May 17th or 18th.
What in the world?
One at a time. They all stood up and said it. It was rather stunning. They gave a lot of other reasons too. Mostly those reasons were voluminous, as we know.
Weren't they
So, but
now?
he has not ruled on that yet. And it's April 27th. He's going to rule on cameras in the courtroom on May 8th. I'm assuming maybe he's going to rule on that on the preliminary hearing then as well. Yes, everyone on his defense team, all 4 people stood up one at a time, including Nestor, and told him that they could not be. I mean, how does he not give him more time? They're basically saying you're going to violate his constitutional rights to effective
Mm-hmm.
counsel if you do
He'll
this.
have
Now,
to.
he
I
could
can't
come back and
imagine.
say, I think you guys are exaggerating this a whole lot, but anyway. And
Yeah.
in a way they are. They're really nitpicking teeny tiny little bits. They're doing the defense attorney thing.
Oh, yeah, of course.
To make it really dramatic
Mm-hmm.
that they don't have everything yet. But I mean, truthfully, they have not even seen the gun yet because the freaking gun is at Quantico. Because the reason this is such a mess is because the FBI jumped in and took
Mm-hmm.
evidence and
Yep.
took it back to federal sites for a
Yeah.
case that is 100% a state case. This will never be a
Mm-hmm.
federal case. There are no federal charges.
No.
There's none pending. There's not going to be any. This is a state case. But the defense definitely is taking advantage of the fact that Sanders is just flipping her tail right in front of my face. But they're really taking advantage of that fact that they don't have everything yet.
Yeah.
And they don't have all the reports and stuff back either. And neither does the state, because they're waiting on the feds.
Yeah.
Yeah. So anyway, that's what's happening in Tyler Robinson. We'll definitely have a ruling on cameras in the courtroom on May 8th. I think we're going to see cameras in the courtroom. There'll be some limitations, but I don't think he's going to kick them out.
I don't either. I don't think he'd dare
I
at this
can't.
point.
Yes, Nestor did claim that she had a death in the family, and that she'd been on another high-profile murder case, obviously, the Richins case. And then other than that, it was a lot of, well, we don't have this, and we don't have that, and we don't have this from the feds. And the fact that they've not even seen the gun yet, but I don't know, the prosecutor was like, I will give you a list of exactly what I am going to present at the preliminary hearing, so that all you have to do is go through that stuff, and you don't have to go through everything. The voluminous amount of stuff. Right. It's a low threshold. And that's what they're saying. They're like,
we're not like it's the trial right now. Yeah.
Right. And you'll have all those things before the trial, but this is just the prelim. I mean, he has not even pled. He's not been arraigned.
Yeah.
He has not pled guilty or not guilty. Like, none of that has happened yet, because they're awaiting this preliminary hearing that will then move the case along. So anyway, I'd be surprised if he doesn't give them. They want 4 months. That's what they asked for. 4 months.
He's not going to give him 4 months.
I don't think so. Nestor, who is the lead in this case, did reassure him that she's had to ask for more time for preliminary hearings, and sometimes that happens 3 or 4 times in a high-profile case. I don't think Judge Graff is going to go for that, so we shall see. Right, they might get a month. They might get a little bit more time. They're not going to get it all. They're really hung up on the DNA and not having a lot of the DNA back, and the prosecutor was like, I'm not even mentioning the DNA in the preliminary. I don't need it. So, I don't know. But anyway, you would think after all that we might have some answers on that, yet we don't. But maybe it's all coming on May 8th. Yeah. So that'll be live over on the Trials channel on May 8th, so that we can talk a little more about that. One thing that is moving forward, that is coming up in 2 days, is a hearing for Aaron Spencer. This is in preparation for his trial that is set to begin on June 22nd. So this hearing, let's see, they just have a bunch of, at this point, it's just all evidentiary motions, some motions to exclude certain prosecution evidence, arguments about what the jury can hear about the victim, Michael Fosler, which is really important. Like, what are they able to tell the jury about the guy that he killed? That's pretty key to his self-defense or in defense of another defense, is that they hear absolutely as much as possible about Michael Fosler and what he did that day, and why Aaron Spencer was so afraid for his daughter. Like, I mean, I don't know if it even matters. Like, if a man takes your child, I know she wants me to pet her, but I do. And then if I have to stop so I can talk, she can't stand it. Also, she's got her hair in my nose, which is driving me nuts. Silly woman. She's a crazy old cat. But anyway, I mean, that's very, very key. The stuff about Fosler is really, really key to his defense. And so, of course, prosecution's trying to keep out as much as possible.
Right. And the old judge had allowed them to keep a lot out. So
right. And this is the new judge. So we shall see. I still think it's ridiculous that this is even going to trial. But
same.
I guess if they've got to get smacked by a jury.
Yeah. It's a huge blow to not be able to bring that evidence in. But it would be insane to me that you can't, considering the meat of the case. But
right. So we shall see. Tyler Robinson, just, you guys are asking about the smirk on his face. It's just kind of his face.
Mm-hmm.
He looks like this in every picture. I don't think
he
he's
does.
intentionally smirky at all.
Yeah.
That's just kind of what he looks like. So that's Aaron Spencer. So last but not least, Caleb Flynn. Caleb Flynn had a hearing last week on Friday. That's finally been released, and I'm going to put it out on the Trials channel later today. But in that hearing, so trial is set for May 4th. In the hearing, his defense attorney asked for the jury to physically visit the Flynn home. He wants them to go see the house, see the layout of the house, and the judge granted that. Interestingly, Caleb Flynn doesn't want to go.
Oh.
And so he has waived his right to attend with the jury to visit the house. I'm not sure what I think about that. I think that's rather interesting that he doesn't want to go.
Yeah.
Or what does he think? What does he think it's saying to the jury if he doesn't go? Does it look like a man who doesn't want to visit the home where his wife was murdered? Is it to garner sympathy? Is it to not connect himself with that location?
Right.
Because that's where she died. It's interesting, but it's interesting to me that he has opted to not go, and the judge has granted that. The other issue that's very big and not yet ruled on by the judge, and that is how they're going to handle the testimony of the Flynn children. They are 9 and 12. The prosecution intends to call them. And so they're still determining exactly how that's going to be handled. Now, an interesting thing that happened in this hearing is that when the defense spoke, and they're, of course, against the kids testifying, he referenced a certain part of the rule and a case that, a reference case for the judge. And then the prosecutor stood up and said, Your Honor, the defense attorney is wrong about that. That particular part of this statute is addressed by this and not that. And the defense attorney had to admit that he'd messed up, and he was going to refile his objection to the kids being witnesses because he had, in fact, messed up, and the prosecutor had called him out on it, which was pretty funny.
Oh, no.
If I were Caleb Flynn, I'd be a little concerned about this. Yes, this case is under speedy trial because remember, this just happened in February.
Right.
And he's all ready, and he is absolutely barreling toward trial. He has no interest in delaying at all. Yeah. So that was rather interesting. So the judge couldn't really rule on anything because the defense needed a do-over, which was, I would be really embarrassed if I was them.
Oh, yeah.
And they're talking about how are they going to take the testimony of the kids, to can they make sure they don't have to see their dad while they do it? Can they make sure, of course, that they're not on any kind of camera while they do it? All of those things, if it's going to be in judges' chambers. Yeah, I mean, all of that is yet to be ruled on for sure. And it's really sad. My God, can you imagine?
No, it's
these
awful.
Kids, 9 and 12, have to testify to what happened the night that their mother was murdered and that their dad is on trial for. But I'm curious to see how they handle it. I mean, the defense can object all they want. I don't think it's going to stop anything. They are first-person witnesses. Yeah. They were in the house when this happened.
These poor kids.
How are kids typically questioned in trials? A lot of times it happens in the judge's chambers, and then it's shown on film to the jury. They frequently have advocates with them to help support them. Obviously they're not shown on live streaming. Yeah, so they just have to set that up.
Yeah.
I don't know if we'll get to hear the children's testimony at all, Bethy. That's a really good question, and I'm not sure that we will. But what a sad place for them.
Yeah.
Lost their mom. Don't really have a choice but to testify against their dad.
Yeah.
He did
And
make
at
them
their
witnesses.
age, that's so hard to
Oh yeah, they're really
compartmentalize.
young.
Yeah.
Yeah,
Oh,
yeah,
terrible.
absolutely.
Oh, hi, sisters. Good to have you here.
Yeah, glad you're here.
Yeah.
Right. I agree with you, Sweet Relief, that the public doesn't need to hear their testimony. No, that doesn't need to be out in the world for them, for other people to use against them in their lives. Like, yeah. Irina wants to know, do you think that Kouri and or Tyler could say ineffective counsel since their lawyer was spread for their cases? No, I don't, because they weren't, because Nestor wasn't the only attorney on either of these
Right.
cases.
They both have a
They have
team
a
of
team of
three.
attorneys.
Yeah.
Yeah, yeah. Richins had 3, and Robinson has 4. So
Plus, they'd have to be able to identify. So it might be too soon to say in Robinson in some ways because we haven't seen how it played out. In Richins, I
yeah.
mean, they'd have to tear apart the trial and everything that led up to it and pinpoint the very specific ways in which the ball was dropped by their attorneys.
hmm Well, and it would have to be attributed specifically to Nestor,
Yes.
and she wasn't even the lead in Richins, so I think that's unlikely.
Yeah.
And where,
Yeah.
yeah,
Lewis was
right,
the
Lewis
lead.
was the lead,
Yeah.
and in Robinson, I mean, they haven't even had a prelim yet, so
Yeah.
it's way too early in the case for that. So
It's a good
I think it
question,
will be
though.
fine.
Yeah.
Yeah, it's very valid. It's like,
Hmm.
it's a weird thing. Idaho and Utah always seem to see this because just aren't that many death penalty attorneys around,
Mm-mm.
that we see the same attorneys on
She
multiple
did act
cases.
like she was the lead. I don't know, but it was
I
my
mean,
take that she was maybe training Lewis. So, you know what I mean? Like sitting
right.
second chair on maybe Lewis's first death penalty case or wait, was
Well,
Richins
but that was
guilty? Maybe it
Richins. It's not
wasn't.
death penalty.
Right, yeah, it
She sure
wasn't.
seemed to be propping Lewis up from time to time. I will
She
say that.
did. Yeah. Red Devils. Right. Maybe somebody needed a few more Red Devils, right?
Maybe they did.
Oh my gosh. I can't
I will
even look
never
at
get over that
Sudafed.
as long as I live.
Yeah.
Well, and I was going through some stuff in my house the other day, and I found a box of Red Hots, and that's all I could think about was, it's Red Devils. So funny. So those are the main court updates I have for you this week. I don't know if Aaron Spencer, if this hearing is going to be streamed or not. If it is, it'll be live. If not, I'll be reporting on it after the fact. I
Hmm.
am going to I am going to put this segment up over on the Trials channel with the Caleb Flynn hearing that I just talked about, so you can see that, because his stuff always comes out after the fact.
Raj, please have a seat. Thank you. Good afternoon. It's Thursday, April 23rd, 2026. We are here on case number 26 CR 88. The matter's captioned State of Ohio versus Caleb C. Flynn. So are you Caleb Flynn? All right, this matter comes on for hearing. Court and counsel had a brief status conference to discuss some particular trial issues. There are several motions that are set for hearing today, and we are going to discuss those here on the record. One being that defense counsel did file a motion for a jury view for purposes of the impaneled jury viewing the location of where this alleged incident occurred. I've spoken with the state with regard to their position on it. Mr. Watkins, would you like to state on the record if the state has any objection to the jury view?
Thank you. Generally, the state does not have an objection to that motion. Counsel for the defendant, the state, had plans to take a look at the location in question and just ensure that it's still in a similar condition as it was at the time. If that's the case, the state won't have an objection to that motion. I know the court has asked both the defense and the state to collaborate and come up with kind of some ground rules for that jury view so we can agree on it. I think we'll get there.
Mr. Mulligan, is that your understanding of what was discussed and your client's position?
Yes, Your Honor, we appreciate the discussion. We're okay with the jury view so long as the kitchen hasn't been moved, the garage hasn't been moved, the rooms in the house haven't been moved. To the extent that I don't even care if the roof is not there anymore, as that's not relevant to this particular case. I would like the jury to be able to see the ingress and egress from the home and the location of the various rooms in the home, so it's really not terribly complicated. Mr. Watkins and I can go there to make sure they haven't moved the rooms.
Well, based upon the parties' discussion and the court's understanding of that, as well as what's been put here on the record, the court finds good cause for granting the jury view. As noted, the state has volunteered to provide some type of layout or map of the home, and the areas that will be viewed by the impaneled jury a list will be provided by counsel for the court to have the jury consider. Typically, the court will have the state of Ohio provide transportation and security for the jury and the court's bailiff. There will be the particulars of all the logistics will be set forth in a formal order by this court. Additionally, Mr. Mulligan, your client has the right to proceed to the jury view as well. What is his position with regard to that?
We were not going to have Mr. Flynn on the jury.
Thank you. I do need to speak with the defendant with regard to his potential waiver of that. So is there any issue with that, Mr. Mulligan?
No, Your Honor. I've discussed it with him, and he's willing to waive his presence on the jury.
So, Mr. Flynn, I need to speak to you briefly about this. Under the state of Ohio, law in the state of Ohio, both as to statute and constitution, you do have a right to be present during the jury review. Do you understand that?
Yes, Your Honor.
Your attorney has indicated to me that you wish not to go to the jury review. Is that correct?
Yes, Your Honor.
Has anybody forced you, coerced you, or threatened you to decide against going?
No, Your Honor.
And is it your belief that at this time you prefer not to go on the jury view?
Yes, Your Honor.
You understand you're giving up a constitutional right and a statutory right to be present during the jury view?
Yes, Your Honor.
All right. Based upon the defense's own request, as well as the defendant's comments here in the court will deem that he has waived his presence at the jury view. All right. Moving on to the second issue, which is the state's motion pertaining to the rights of a child witness when testifying. The state filed this motion just here recently, and defense counsel has provided a memorandum in opposition. At this time, would counsel Mr. Watkins, would you like to present testimony, or would you just like to make a statement with regard to your motion?
I think a statement would suffice, Your Honor. As my understanding, the defense is willing to stipulate at this time that there will be minor children testifying potentially at this hearing. I think that's as far as the stipulation goes that we referenced.
Yes.
With that,
Not to the ages? Are you stipulating to the ages, Mr. Mulligan?
That's fine, Your Honor.
the ages would be 9 and 12, Your Honor.
Thank you. Go ahead.
Thank you, Your Honor. The defendant filed a response to my motion yesterday evening. In that motion, they asked the court to focus on Ohio Revised Code Section 2945.481. I believe the defendant has done that because he knows he has no argument against the state's motion as written in regards to Revised Code Section 2945.483. The state is just simply asking the court to enforce the rights that these young children have while they testify in this court.
Thank you, Mr. Watkins. Mr. Mulligan, at this time, would you like to make a statement?
Yes.
Response.
I would point the court to State v. Johnson, which was a unanimous decision for the Second Circuit Court of Appeals. It was decided on March 6, 2026, and in that case, Judge Huffman, Judge Lewis, and Judge Tucker unanimously overturned the Johnson matter. There is no question at this point, based on the statement that has been made thus far, that there's been no showing whatsoever that these particular children are unable to testify. There's been no case-specific findings that any preventative or precautionary measures are necessary, and a review of State versus Johnson would suggest that, particularly in the absence of case law on Section 483, that it runs the potential of reversing this case if the rights of Mr. Flynn are violated. In that particular case, they specifically found that it was harmful error and overturned it. And I think that that would be applicable to this case as well. So I would ask the court to review that particular case. The citation on it, it's Court of Appeals number 30506. I believe the citation on that would be 2026-Ohio-757. So I'd ask the court to review that as well. Thank you.
Thank you. Mr. Larkins?
Thank you, Your
Any
Honor. Just-
further?
Yes, Your Honor, just in response to that, Johnson case just cited by the defendant refers to that .481 section and requirements of 2945.481. The things that Mr. Mulligan just mentioned are required under that .481 statute. The legislature did not include a single one of those in .483.
Well, the court will take the matter under advisement as to the child witness testifying under 483 of the revised code of 2945, issue a written decision. Otherwise, this matter is scheduled for a 2-week trial, at least a 2-week trial to begin on May 4th, and we will be proceeding in that fashion. Are there any other matters we need to discuss? Mr. Mulligan?
There's some suggestion in the Johnson case that, and I understand that I filed a written objection in this particular case of the child witness testimony. I believe I'm required to preserve that error, so I would ask for permission to do that.
We met.
Thank you.
Anything further from the state?
No, Your Honor.
We are adjourned.